SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law again. This is our 5th module on Maritime Law, which will be dealing with nature, content and jurisdiction under Admiralty Law. I am Dr. Ashutosh Acharya, Senior Assistant Professor, Law Center 2, Faculty of Law, University of Delhi. And today, in continuation to our previous classes, we will talk about Admiralty Law. That is, we will specifically now begin with relationship between ship, sea and state. In the first class, we had entering into those zones are concerned. What is the domestic law's take as far as the ships are concerned? Well friends, all of us are aware that sea route is largely used for transportation, and when such transportation either of goods or of individuals, that is people, person, individuals take place, what are the rules as far as their breach of obligations are concerned? Once they are in public or private breach, can the domestic legal system take any action? In law of the sea, we understood that within territorial waters or within territorial sea, it is the legislative jurisdiction or territorial jurisdiction that gets applicable as far as the territorial waters are concerned. Then, if territorial jurisdiction is applicable, what is the law that can be made applicable as far as territorial jurisdiction is concerned? It is the Admiralty Law that largely deals with jurisdictional aspects, and that is why in the next 3 modules, including the one of this class, we will talk about claims and jurisdiction. Well friends, the idea of claims and jurisdiction is not a new idea. It has been in existence since a longer period of time, since thousands of years. But when we talk about formalization of these claims and jurisdictional aspects, we can trace it back to at least 1000 years before. If not, we can see that 800 years before, the actual formalization started, especially the recorded ones if we identify from 13th century. Then in 14th century, we see the growth of formalization of this domestic legal system as far as jurisdiction and claims are concerned, because the peculiarity of this particular subject is that the ship that is entering into your territory is a foreign ship, and the law that you apply on this particular foreign ship is domestic law. Can you apply domestic law on the foreign ship? Because at the same time, the ship is having freedom of navigation. But as we have discussed in the last classes, while we try to understand the solution of the conflict between the coastal states concerns and the flag states concern. Flag states concern is residing on the premises of flag state jurisdiction as well as freedom of navigation, and coastal states rights are residing on the premises of exercise of jurisdiction in order to protect its safety, in order to take care of its security. But this exercise of jurisdiction is not only now restricted to safety and security, but also goes to the application of laws. Whatever laws are passed and applicable within the land territory also gets applicable up to 12 nautical miles in sea territory as well. So, as far as exercise of jurisdiction by a particular court is concerned, then that jurisdiction will not only extend up to land territory or is not limited to coastline, but goes beyond the coastline, goes beyond the shore and extends up to 12 nautical miles, wherein for certain particular purposes it can also go beyond 12 nautical miles in the contiguous zone, as we have already discussed as far as matters pertaining to excise, customs, fiscal etc. are concerned. So, once you identify under unclause and states accept that particular right and obligation provided under unclause with respect to application of jurisdiction for all matters or for certain matters, then how does domestic law reacts, or how does domestic law come into being as far as exercise of jurisdiction over all those matters are concerned. So, it is Admiralty law, friends, that deals with claims and jurisdictions. So, in the 5th module and 6th module and as well as in 7th module, we will talk about Admiralty law, which, as I have already said, will deal with claims and jurisdiction. What are the claims and whether a court can have jurisdiction? What is the law pertaining to jurisdiction? And what are the different types of claims for which jurisdiction can be taken into account? Well, friends, it has a long history. India has recently passed an act, that is in 2017, and amended a little bit in 2018 and then in 2021 as well. At the same time, we see that prior to 2017, attempts and efforts were made in order to codify the law pertaining to claims and jurisdiction. However, for such a longer period of time, even post independence, we were not having an indigenous concrete Admiralty law. However, there were laws of Admiralty in existence of pre-independence times, of the British era times of 19th century, still in continuation to be in existence. Whether they were sufficient enough, whether they were not sufficient enough, will also be discussed in today's class. So, friends, let us understand the objectives of today's class, and that would be to learn about the background and brief history of Admiralty law in India. So, we will go through the last 500, 600, 700 years of historical background, especially the ones where we see how those historical moments have helped grow and develop Admiralty law in general, and also as well as in India, how it has come into being. Then to understand the behavioral aspects of Admiralty law. How does Admiralty law behave? Since I have already told you that there are certain nature, specific or peculiar aspects pertaining to Admiralty law. For example, the ship is foreign, the law applicable is domestic. So, it has a very peculiar feature as far as application of domestic law on foreign ship is concerned. How traditionally such things were developed. So, for example, one of the peculiar feature that we can identify is that a ship is considered to be a floating island for all purposes of flag state jurisdiction. It is a legal fiction that we have undertaken. So, therefore, taking into account ship to be a floating island, ship at the same time for the purposes of claims and exercise of jurisdiction is also considered to be a legal personality, and this is something which has been recognized through traditional common law cases. Since a court cannot wait for the owner to come from a foreign land into the domestic jurisdiction, situations might be of such a nature that a res of the owner, that is the property of the owner, can be treated to be a legal personality, since a case is largely filed, if you see, against the ship itself rather than filing it against the owner, because if the case is filed against the owner, then we will have to wait for the owner to appear before the court. So, once a res, that is the ship, is charged for certain wrongful acts, then that particular ship itself can act as a legal personality. Suit can be filed against that particular ship itself, and recovery can be made from the ship itself, either through its constituent body parts or from the whole ship itself. So, such are some peculiar features. We will discuss those aspects in detail in today's lecture and as well as in the next lecture as well. Thirdly, to understand the legal peculiarities and features of Admiralty law. Now, friends, till the year 1354, we see that it can be said that there was not an Admiralty court in reality, though minor attempts were made to transfer matters pertaining to piracy and spoils to be tried by the Admiralty court. However, it ultimately were decided by the council as per the common law. Up to this point, we do not find any reference of Admiralty court deciding any matter pertaining to piracy or spoil. Also, we do not see any mention of Lord High Admiral or Admiralty court intervening in the administration of justice. Till this time, the field of admiralty is only 50 years old without a significant contribution, and therefore can be said to be a new one. Many admirals were appointed since Desestas and Lebon, but their commands always fell short of duration, limited to a particular service, and always to the charge of a part only of the king's fleet. Taking this into account, it can be observed that admirals probably were used as a regulatory and monitoring body, and it does not appear to have been holding the power to administer justice in the maritime cases. Restitution of spoiled goods and arrest of foreign ships and goods by way of reprisal have been made by the processes issued from Chancery, the Council or the common law courts. So, largely friends, we find the origin of admiralty, court and admirals and the whole idea of admiralty cropping up from common law system, and therefore, if you trace back, before 700, 800 years before, we will see that there was less mention in 14th century as far as admiralty and admirals are concerned. Less power or no power was provided as far as administration of justice is concerned in the hands of admirals, and therefore, we see it is only largely councils and chancery that is largely dealing with administration of justice. But we will see that with the advent of time and with the passage of time, how English courts and English administration went on to give more powers to admirals and ultimately led to development of the whole aspect and idea of admiralty. And therefore, in the year 1360, a person named John Pavelly was appointed as the captain of the fleet with disciplinary powers. This appeared to be an erection of the Maritime Tribunal, and a few months later the command of the North, South and the West fleet was handed over to Sir John de Beauchamp, succeeded by Sir Robert Hurley in the year 1361, having additional power of maritime jurisdiction and power to appoint a judge. So, these are some of the instances that we see in the passage of the year in 14th century, where we can trace the incidents where the development and progression of admirals and admiralty scenario is coming into being. This gave the admiral full power to hear plaints touching the office of the admiral, power to take cognizance, to punish, to set free and any other maritime offences of the like nature. So, due to the requirement of the time in 1361, we see certain powers pertaining to administration of justice and executive powers were handed over to admirals. And this is how we see coming into being of admiralty jurisdiction as far as admirals are concerned. Separate admiralty court so far was not in existence, but we will see in later points of time admiralty court coming into being in order to specifically deal with the matters pertaining to jurisdiction and claims. Further, admirals, apart from struggling to gain its recognition as a distinct and viable dispute resolving institution, had to face a lot of rejection from the common law courts. Now, we see that common law courts started rejecting the decisions and the exercise of power by admirals. Now, this was for very basic reason that the initially when the power was in the hands of common law courts, a certain specific subject matter was now handed over to admirals. So, they were reduced from their exercise of power, especially with respect to ships and admiral matters are concerned. So, common law courts were not that happy as this power shift happened in those eras. Now, which rejection from the common law courts, which already was an institution established to administer justice delivery system. Therefore, one of the medieval solutions identified was that in the year 1389, an act was passed entitled An Act Concerning What Things the Admiral and His Deputy Shall Meddle. It provided that the admirals and the deputies shall not meddle henceforth of anything done within the realm, but only of things done upon the sea, as it hath been used in the time of our noble Prince King Edward, grandfather of our Lord the King that now is. So, they went on to pass an act which restricted or limited the powers of administration of justice with respect to admirals. So, admirals were given the power to have administration of justice under their domain only if they are away from the shores of England or from the realm. If they are within the realm, or if their existence is falling within the domain of the realm, that is the kingdom, then the admirals will lose all of their powers that they are otherwise having when they are beyond the realm. The first book or first guideline that we can see as far as admiralty matters are concerned is known as Black Book of Admiralty. Friends, it is one of the most revered compilations in England, and as I have said, is known as Black Book of Admiralty. Selden calls it the jewel of Admiralty records. The rules mentioned in the book are partly derived from the laws of Oleron and the Rhodian Sea Law. Now, these are the laws, some of the laws which were applicable when law merchant was in existence, that is, in Mediterranean Sea, when transportation used to take place between different countries of Europe or different regions of Europe, or also sometimes in Africa, we see that these areas in Oleron or in Rhodes, we see different private bodies, guilds have developed their own legal mechanism in order to resolve dispute between merchants, between two shippers, or between two individuals having commercial transaction through sea route. So, which may be with respect to people, with respect to goods also. So, we see such individual laws coming into being, and they were certain laws which were largely accepted, were considered to be a standard form of legal regime as far as dispute resolution and uniformity as far as follow up with respect to commercial transaction through ships are concerned. So, therefore, we see that it is the Black Book of Admiralty noted down certain aspects of the laws of Oleron and Rhodian Sea Law. The uniformity of acceptance of the book can be witnessed in its expansion. It is through decision of cases that Admiralty law developed all around the Europe and were recorded in books, and wherever these European nations went and established colonies in different parts of the world, these laws travelled with them and stayed. It should be noted in this light that up to the end of 16th century, a general maritime code developed at Mediterranean Sea and applied by maritime courts of many countries, and as mentioned, it was an outgrowth of the decided cases. Although no record is available prior to 1520, summary of the decisions of the past cases have helped develop the law. These codes so developed earlier were to be enforced by the guilds. Now, who are guilds, friends? It is a body that is formed by the culmination of different merchants and as well as shippers and all the concerned parties as far as maritime transactions are concerned. So, this particular body will make certain uniform rules which will be applicable as far as transaction through sea, or even in domestic system we have seen at the port of Banaras also there used to be guilds. So, any transaction that used to take place through by using Ganga as a route to travel from one port to another port, in the port of Banaras, guilds was the body that used to make rules pertaining to port, pertaining to ship, pertaining to goods that will be unloaded, that will be loaded. So, all of the administration with respect to maritime transaction or with respect to internal waterway transaction can be seen to have been identified through these guilds, and they were not authorized, or you can say they were not interfered by the state, by the king or any political superior of that particular point of time. So, we see for maritime transaction also in Europe there were guilds who used to frame and make laws in that particular area. So, these codes so developed earlier were to be enforced by the guilds and not by the courts, and therefore, they developed irrespective of the ruler or the government. It later assumed the shape of the custom based upon the practice, and it so developed that even today we see certain rules existing in conventions and treaties which were part and parcel of a long standing practice for so many hundreds of years. Further, friends, Black Book is a book containing list of matters and parties to be punished or against whom adverse order is to be released. In the year 1364, Black Book of Admiralty shows that the Court of Admiral seems to be recognized by the court at Westminster as court of records. There are records of criminal and civil matters being tried by the jury or the juror at the Admiral's Court, largely beginning from 1367, continuing smoothly with few hiccups till the end of 14th century. Admiralty courts were given the power to not only Admiralty courts were given the power to only piracy and spoil cases, that too of civil nature. However, things began to change after Henry VIII became the king, as cases dealing with mercantile, shipping and commercial matters were also being tried by the Admiralty courts. So, we see a shift and expansion of jurisdiction as Henry VIII came into being, and this expansion of jurisdiction allowed the Admiralty matters not only to deal with piracy and spoils, but also deal with certain mercantile matters as well. The feeling to jealousy amongst the advocates of the common law court was quite visible. In a way, this can be credited to the famous Portuguese navigator Vasco da Gama, as he reached India on May the 27th, 1498. After that, Europe became aware of the route to the land of opportunities. Trade began to flourish, and this led to increase in trade at Europe, including England. This enhancement led to increase in the number of traders, merchants and ships, ultimately leading to the growth in the shipping industry of the 16th century at England. Dealing with matters of ships, domestic and foreign, in turn therefore matters pertaining to charter parties, insurance, average, freight, non-delivery, damage to cargo, negligent navigation by masters, mariners, breach of warranty of seaworthiness, in short all kinds of shipping transactions were being dealt by Admiralty court. These are all matters which are also still relevant today, and we have an expanded list also. In the Act itself, if you look, if we will see in the next module when we discuss Admiralty Act 2017, you will realize that more than such claims or more than the I have just mentioned here have been dealt under the Act itself. So, now the law is pretty much codified, and it is those codified claims that comes or falls within the domain of jurisdiction of the domestic system. Moreover, it could be seen that bills of lading, bills of exchange, charter party contracts have been recognized far more fully than common law courts. The later half of the 16th century witnessed some more developments in the field of Admiralty. In the year 1562, a statute was passed known as an Act of Maintenance of the Navy that gave power to coordinate amongst the other judges of Admiralty. This power of coordination was entrusted to the Lord High Admiral of England and Lord Warden of Cinque Ports, their lieutenants and judges, to enforce forfeitures given under the statute. This led to reduction in its previous character of being feeble and sporadic, ultimately empowering its organizational structure. However, this also did not bring the rivalry of the common law court and the Admiralty court to halt. Rather, it continued to grow to a substantial extent. Therefore, in the regime of King James I, that is from 1603 to 1625, who was not much fond of common law judges, summoned a meeting to discuss the general jurisdiction of Admiralty courts, thereby expanding further the jurisdiction of Admiralty court. However, towards the end of 16th century, as the political power of the state grew in size, the independence of the general sea law got compromised, and as a result, state undertook the jurisdiction of Admiralty matters. The outcome of this was enactment of Maritime Code in 1561 in Denmark under Frederick II, which was later followed by General Code in 1683 AD under Christian V. Later Christian XI enacted Maritime Code 1667 AD in Sweden. Louis XIV in his time enacted Ordonnance de la Marine of 1681 in France. This was considered the masterpiece of draftsmanship, which was based upon established customs of sea. On the same lines, Holland in 1721, Prussia in 1727, Spain in 1737 passed marine ordinances. So, we see that a substantial number of ordinances coming into being, codification now coming into being, especially the area of Admiralty and maritime transaction getting covered by the aspects of codification, and different states, almost all of Europe is now moving towards codification and codifying Admiralty or maritime laws, especially with respect to claims and jurisdiction. Now, in France under the reign of Napoleon during 1804 to 1807, codified laws pertaining to maritime laws, and this codification known as Code Napoleon. Maritime law usually purported to codify pre-existing precedents, ordinances, customs, usages and practices. Thus, form of the law changed without changing the subject. Appearing in various national garbs, the content and principles remained same. This can be witnessed in the present maritime law, wherein we find very less dissimilarity in civil and common law countries as compared to other branches of law. Since the transaction was of uniformity, the problems pertaining to maritime transaction was same and similar in nature, and therefore, the solutions were also, when they grew, were similar or common, irrespective of the fact that whether it is a civil law country or a common law country. Since out of necessity the requirement of uniformity comes into being. Now, C.K. Allen says Roman law has always been authoritative in admiralty jurisdiction in England, which is, you can say, a sort of influence of civil law in the common law system. Though it must be noted that by the end of the Napoleonic Wars in 1815, the importance of admiralty code grew to larger extent as Britain was now recognized as prominent maritime nation. Modern times, in 19th century, we see that a new phase of admiralty code comes into being, separate recognition, separate laws, acts coming into being, in fact not getting restricted. If you look at England, English laws not getting restricted only to England or British regime or the United Kingdom area, but also went on to extend and expand to its colonial parts such as Australia, such as Canada or such as India as well. So, we see the 19th century witnessed a substantial rise of admiralty court and its jurisdiction. A series of legislation with respect to extending the jurisdiction of the court of admiralty in terms of subject matter and area were passed. This happened more so because of the characterization of the modern admiralty actions as it introduced the action in rem. So, action in rem is something which comes up as a remedy to a claimant. What is action in rem? And in rem would mean against the whole world. So, when you can bring an action, you file a suit as far as protection of your interest is concerned towards a particular res or a property which is applicable against the whole world. So, your right is secured against the whole world, or your right is, even if not secured, is available against the whole world. You will have the preferential category right against the other claimants. So, action in rem is filed against, it may be filed against a res, that is a property. In case of admiralty matters, it will be filed against the ship or the goods, and when it is done, if action in rem suit is filed, then you have the right against that particular property against the whole world. And as opposed to the idea of action in rem, we have action in personam, where a suit is filed against an individual and not against the property, where your right exists against the whole world, even against the owner of the property itself. So, we will discuss this particular aspect in the next module in detail also. Now, following are the laws that were passed: Responsibility of Ship Owners Act 1813, Wages of Merchant Seamen Act 1819, the Cinque Ports Act 1821, Act for Registering of British Vessels 1825, Vice Admiralty Codes Act 1832, Privy Council Appeals Act 1832, and many other acts such as Foreign Enlistment Act, Slave Trade Act, Pacific Islanders Protection Act, now Colonial Courts of Admiralty Act or County Courts Admiralty Jurisdiction Act 1868. Now, I will just point out here that when we talk about Colonial Courts Act, this act allowed the Britishers to import their own laws into their colonies, different colonies, as I have just told you, in Canada, in India or in Australia or in other parts of the world. Now, as far as India is concerned, as I have said, through Colonial Courts Act, we can see the British laws getting applicable in Indian territory, but at the same time, we also see that with the passage of time, the Admiralty Courts Act was in existence, but no new law or codified law was brought into being as far as admiralty matters were concerned. And the question that whether British laws are still applicable in India or not, because no separate law for India was passed, such as Evidence Act or CRPC or CPC. Therefore, if particular law, which is admiralty law, passed in England, but only applicable in India, will it continue to be applicable in India just because there was another act for India that was passed, and it was Colonial Courts Act for India. Now, if it continues to be applicable in India, then there is another problem. The other problem is with respect to jurisdiction. Now, when Britishers were present in India, the jurisdiction of high courts were identified, and these high courts were largely residing in the presidency courts. So, presidency courts were identified, Kolkata, Chennai or Mumbai for that matter. Now, whether the high court of the independent India or high courts established post independence, whether these high courts established under the constitution will have the same jurisdiction that the presidency court was having. Now, this was something of a doubt which was persisting for a longer period of time, and there was lack of clarity as far as trying of admiralty matters was concerned, that whether the high court of the present times can have jurisdiction as far as admiralty matters are concerned. Now, this question was raised, or similar questions pertaining to the same subject matter were raised in a case known as M.V. Elizabeth versus Harvan Investment and Trading Private Limited, Goa. In 1993, it was decided. Now, brief facts would be that the plaintiff company was in Goa and the offending ship was a foreign ship owned by a foreign company. The ship left the port of Marmagaon in Goa carrying cargo of the plaintiff to a foreign port without issuing bills of lading. Now, bills of lading, friends, is a document which is equivalent to the document of ownership of a particular good and other documents, and discharge the cargo at the foreign port, notwithstanding plaintiff's instruction with respect to right of disposal. Right of disposal is a concept which says that goods are not to be handed over till the payment has been made, and there, or you can say, if the ownership is not transferred, the transaction is not deemed to be a complete transaction. So, goods must not be disposed or ownership must not be transferred unless and until payment is made. So, right of disposal instruction was in existence. Even the sale of goods of India deals with under section 25 right of disposal, and therefore, when we talk about this particular aspect, there was certainly a dispute between the two parties, that is M.V. Elizabeth, this ship, and the Harvan Investment and Trading Private Limited, Goa. And as any action could be taken by the authorities in Goa or by the owner against the ship, that is the company here, the ship moved away from Goa and went to the port of Visakhapatnam. And as we see that the plaintiff claimed damages for conversion of the goods and for breach of defendant's duty under the law relating to the carriage of goods by sea. When the ship later entered the port of Visakhapatnam, the plaintiff instituted an admiralty action in the High Court of Andhra Pradesh. Now, whether a High Court of Andhra Pradesh can have jurisdiction is the question here. Now, with respect to this particular question, that whether Andhra Pradesh High Court will have jurisdiction or not, the Supreme Court was now to decide upon this particular matter, as M.V. Elizabeth reached Supreme Court, or you can say via its owners, they reached to the Supreme Court, claiming that since India does not have concrete law, codified law that endows jurisdiction upon High Court with respect to admiralty matters, therefore, High Court of Andhra Pradesh will not have jurisdiction. Supreme Court upheld the jurisdiction of Andhra Pradesh High Court. The apex court said the admiralty jurisdiction of the High Court is dependent on the presence of the foreign ship in Indian waters and founded on the arrest of that ship. The jurisdiction can be assumed by the concerned High Court whether or not the defendant resides or carries on business within the local limits of jurisdiction. We see that M.V. Elizabeth case was a landmark judgment in the history of recognition of admiralty jurisdiction. An action in rem was instituted by the one Harvan Investment and Trading Limited against the ship known as M.V. Elizabeth, as we have already discussed. Now, we here see that the High Court ordered arrest of ship later on following proper procedure, and then it was claimed by the owners of the ship that M.V. Elizabeth, that the High Court of Visakhapatnam lacks appropriate jurisdiction to try the matter. So, the Supreme Court of India said that previous decisions, the High Courts have applied Admiralty Courts Act 1861 by virtue of Colonial Codes of Admiralty Act 1890, which here we can understand that court did recognize Colonial Codes Act and said that since a separate law or a new law, a fresh law is not available post independence after coming into being of the constitution also, then the previous laws available gets applicable mutatis mutandis. Therefore, we are now faced with the question that whether the presidency court's jurisdiction will automatically pass upon the high courts, and the Supreme Court upheld this particular argument as well, that yes, the presidency court's jurisdiction will now pass upon to the high court's jurisdiction as far as admiralty matters are concerned. It said that this has led to non-updation of admiralty laws in India. Thus, as a solution to this issue, the Supreme Court in present case, overruling its previous decision, held that the high courts in India have all the inherent and plenary powers as a superior court of record, and therefore cannot be tied down to admiralty jurisdiction as it stood in the year 1890 under the Colonial Courts of Admiralty Act 1890. The Supreme Court in this case pointed out that the high courts sitting as a court of admiralty under the Indian Constitution cannot be treated as separate entity exercising a distinct and specific or prescribed or limited jurisdiction. That admiralty jurisdiction is a part of the totality of the jurisdiction vested in the high courts as superior courts of record, that whatever may have been the relevance of Urimaru case to courts like exchequer courts in Canada, there was no reason why the jurisdiction of Indian high courts functioning under the Constitution of India should in any way be subjected to the jurisdictional fetters imposed by Privy Council in that decision. That it is well within the admiralty jurisdiction of Indian high courts to entertain even questions and claims catalogued in section 20 clause 2 of Supreme Courts Act 1981 of the UK, based on the International Convention for Unification of certain rules relating to the arrest of sea-going ships, Brussels, May 10, 1952, that in the absence of any Indian statute defining a maritime claim, Indian high courts as courts of admiralty can entertain such questions and claims as part of international common law, rooted in and evolved out of general principles of national laws of maritime countries, which can be adopted and adapted by courts to supplement and complement national statutes on the subject. Now, apart from this particular decision, if we look at the history of maritime jurisdiction and admiralty in India, we can trace back from 17th century, starting from the arrival of East India Company, then factories at Surat, Agra, Ahmedabad, then Bombay was transferred to the company. So, we have this series of historical instances which have led to the admiralty matters coming into India, development of admiralty jurisdiction in India, and then also we see that in 1861 Indian High Courts Act through charters, later patent of 1862 and 1865 was established, and then in 1890 Colonial Courts of Admiralty Act was passed, and then in 1993 MV Elizabeth case we learn that Supreme Court overruled its previous decision and upheld that yes, high courts can have jurisdiction, all the coastal high courts can have jurisdiction. So, in order to codify or attempts to codify, if we see the first attempt that was made was in 1986, and for which Praveen Singh committee was established to make India's maritime law and admiralty jurisdiction up to date and more responsive to the needs of industry. At the same time, we see that in 1976 certain updations were made, substitutions were made as far as Merchant Shipping Act is concerned. Now, this Merchant Shipping Act was passed in 1958, but it does not talk about the jurisdictional aspect and claims aspect. It does provide what claim can come into being, but for what claim jurisdiction, admiralty jurisdiction can be taken care of, Merchant Shipping Act does not talk about, and therefore, there was a requirement of separate Admiralty Act into being. And therefore, in 1994 First Law Commission report comes into being, which proposed of a PSC to establish distinct, Praveen Singh committee to establish distinct Admiralty Court was rejected. So, there was distinction between the 151st Law Commission report and Praveen Singh committee report, as Praveen Singh committee report said that we must have a separate Admiralty Court, but Law Commission said we need not have a separate Admiralty Court. Admiralty jurisdiction should go to the High Court. Since the nature of transaction is international, therefore, the jurisdiction to extend to the entire coast of India, including its navigable inland waters. Unlike in the civil law countries, the two distinct admiralty actions, namely action in rem and action in personam, are to be preserved. However, discretion should be expressly vested in the court. The legislation should be based on Supreme Courts Act 1981 of England. Now, this was one of the important suggestions that was made by Law Commission report. Now, there are certain other conventions that are to be taken into account, if you see, for unification of certain rules, and then unification of certain rules pertaining to assistance and salvage at sea. Now, when you draft your domestic legal system, it must be in consonance to international system. It certainly should take into account the domestic concerns and interests, but largely it should follow the international convention as far as unification of rules are concerned, because when a ship travels from state A to state B or B to C or C to A, if there is no uniformity, then there can be problems pertaining to reciprocity. There can be distrust or mistrust amongst states as far as application of law is concerned, which will ultimately hamper transportation, commercial transaction between the states. So, there are different laws that should be taken into account, which are present at international scenario. Now, when we talk about the behavioral aspects of Admiralty law, some of the behavioral aspects such as legal personality of the ship, action in rem, and interaction of international legal system with domestic legal system, we have already discussed to a certain extent, and how history has played its role in culmination and formation of the Admiralty law as far as domestic scenario is concerned. Okay. Now, if you look at the nature of Admiralty law and maritime law in general, as I have already told you that maritime law is municipal, but having international aspects. Further, it is an independent legal system. Thirdly, it acts as a part of law merchant. Fourthly, maritime law in relation to public and private international law. So, it is public, at the same time it also has certain private features. Then maritime law in relation to common and civil law, and what are the sources of maritime law. So, moving further, we can see that how maritime law is municipal law and having international aspects. Well, most of it we have already discussed, and we know that since the trade is seaborne, it automatically is international, but the law, Admiralty law that is applicable on the ship is domestic in nature, and therefore, it is a municipal law having international aspects. And since we talk about unification of rules, automatically we can say that there is significant influence of international law into the domestic legal system. Even if there is lack of absence of any particular law on a particular subject matter or on a particular claim, it does not mean that no claim can be brought into picture. The help of international legal system can be taken into account on the basis of equity, and on equitable grounds court can provide remedy to the claimant. We see that further the maritime commerce by its very nature is international, however, it is enforced through municipal legal system. The bulk of established norms and principles originated from necessities of seaborne trade and commerce involving transactions. If you look at certain important sayings, Lord Mansfield in Luke versus Lyde has said, maritime law is not the law of particular country, but the general law of nations. In Tolton's case, Lord Justice Scott has said, uniformity of sea law throughout the world is so important for the welfare of maritime commerce that to aim at it is a right judicial principle. So, there is not maritime law of the world, but maritime law as adopted by all maritime nations of the world, which may be described as customary rules developed as common law of the sea. Since the practice is so far along in time quantitatively, there are certain uniform practices that have developed, and now they are existing in a codified form. We see that Lord Justice Scott in the case of United Africa Company Limited versus owners of M.V. Tolton has said, originally the Admiralty jurisdiction, both civil and criminal, was unlimited over the high seas. The present jurisdiction of the Admiralty division of the High Court is based partly on statutes, but primarily and mostly on principles previously adopted by the Admiralty Court from the general law of the sea, observed by Western nations, instanced in early times, example by the laws of Oleron, and in later times widely followed in general practice of continental nations. It has been characteristic of English judges exercising Admiralty jurisdiction, as I have already said, to look to the general law of the sea for two allied but distinct purposes: to resolve doubts on a question of English law by adopting what they believe to be the relevant rule of the general law; secondly, as a principle of judicial policy in order to avoid creating divergence of our law from the general law. The importance to maritime commerce of uniformity in all seas the world over has received frequent emphasis both before Judicature Acts and since, that is the Act of 1981. We see, and for this reason I regard it as relevant and proper to follow judicial precedent and resort to the general law of the sea, following in the wake Lord Stowell and Dr. Lushington in order to resolve any doubt there may be about our law and to preserve international uniformity of maritime law. In this light, we may consider that under UNCLAUSE 1982 provides for extent of territorial jurisdiction of a state which shall extend up to 12 nautical miles from the baseline of the coastal state. This range of sea comes within the legislative jurisdiction of the state, and a state can have subject matter jurisdiction over vessels within an ordinary civil and criminal jurisdiction can be exercised. Therefore, the nature of admiralty law is a mix of domestic and international features, since a foreign vessel's jurisdiction by a state can be assumed under international law, and this can be enforced under municipal law. Therefore, moving further, we also see that it exists as a sui generis system, or we can say that it is an independent legal system. Admiralty jurisdiction is vested in the high courts, however, it has its own peculiarities and is sui generis. Why? Because it has developed a jurisprudence of its own. Principles around the world are fairly universal in application. Therefore, it is also said that admiralty and maritime law is considered to be one of the major surviving legal systems of the world, since there was lack of interference from the political aspects and other types of international relations aspects. We see that it has independently grew and developed out of the system of law merchant. Though admiralty law in contemporary times is codified, however, when it was not codified, the admiralty courts took help of customary laws which were found to be international in character under the idea of comity of nations. Even if a nation has not codified admiralty law, the objective of ensuring justice would never restrict the application of admiralty law in different jurisdictions. Law merchant being part of jus gentium arising since the times of Roman Empire. Admiralty law as part of law merchant. One of the essential part of business is transportation of goods from one place to another. Earlier law merchant dealt with such area of governance that takes into account the peculiarities of merchant transaction. Therefore, interest of merchant and interest of ship owner were run together. We may formulate that law merchant is constitutive of commercial law and maritime law, including admiralty law. Sir W.S. Holdsworth in A History of English Law has noted that the law merchant of primitive time comprised both maritime and commercial law of modern courts. From the earliest period in their history, an intimate relationship had subsisted between them. Both applied peculiarly to the merchants, who, whether alien or subject, formed in the Middle Ages a class very distinct from the rest of the community. Both laws grew up in similar manner from the customary observances of a distinct class. Both laws were administered in either the same or similar courts which were distinct from ordinary courts. Both laws differed from common law, both had in the Middle Ages an international character, and both continued to possess this international character right down to modern times. Admiralty law in relation to public and private international law. Since common law countries largely have dualist approach, especially when we talk about India, it is a dualist country that any international law to be implemented in India has to have a domestic approval through legislation. So, therefore, dualist approach in application of public international law, but when we talk about private international law is an offshoot of the common law of England designed to meet international fact situations in common law actions. Elsewhere, it is part of civil law administered in ordinary civil courts. Though Admiralty Court has to deal with international fact situations with a marine element on most occasions, it does not necessarily apply private international law as evolved by common law courts. It follows a legal system of its own, and some of its peculiar legal concepts such as action in rem, maritime lien, arrest of ship, limitation of liability. Generally, we will see such liens coming into being in domestic legal system, but we have a concept of maritime lien. A charge is created over a particular ship is considered to be legal personality, a ship can be arrested, and concepts pertaining to limitation of liability. So, these peculiar features make the distinct make admiralty law a distinct area. At the same time, they also form part of public or private aspects. So, when we talk about action in rem, maritime lien, arrest of ship, limitation of liability, they are known to private international law and administered in common law courts. So, largely it may be as far as action in rem is concerned, brought against one particular ship, or res against the whole world, private matter. At the same time, maritime lien against a particular ship, a private aspect. A ship when gets arrested, again it does not affect the public at large. So, these are some private aspects which are part and parcel of private international law and gets applicable within the domestic legal system. This comes up as a result of exercise and practice of common legal system. Historically, Court of Admiralty in England and not common law court was the first to extend jurisdiction to foreign causes. Further, when we look at Admiralty law in relation to common law and civil law, we see primarily Admiralty law is distinct and a special law because of its distinct origin, history, field of application and distinct courts that used to administer it. Admiralty law and jurisdiction in India has been kept separate from the ordinary civil jurisdiction by the provisions of section 4 clause 1 and section 112 clause 2 of CPC. Section 4 clause 1 says that in the absence of any specific provision to the contrary, nothing in this code shall be deemed to limit or otherwise affect any special or local law now in force or any special jurisdiction or power conferred or any special form of procedure prescribed by or under any other law for the time being in force. Section 112 clause 2 says nothing herein contained applies to any matter of criminal or admiralty or vice admiralty jurisdiction or to appeals from orders and decrees of prize courts. So, an exclusion has been made by the Civil Procedure Code as far as admiralty law and jurisdiction is concerned. The provisions of the code, unless any of them specifically and expressly deals with admiralty matters, are inapplicable if they are repugnant to the rules of practice and procedure in admiralty jurisdiction. The provision is based on the general principle of generalia specialibus non derogant, which means that special will prevail over general, which means that the code of civil procedure will not override any subsequent special law. Therefore, in Meyer versus Owners and Parties, MV Fortune Express, we see foreign jurisdiction clause has held. Therefore, when you look at the sources of maritime law and admiralty law, we see that, as we have already seen in when we were discussing brief history also as far as admiralty law is concerned, that Rolls of Oleron, Black Book of Admiralty, at the same time Rhodian laws, we see that how admiralty law got developed from these parts or from these areas, especially in the modern development of admiralty legal system. And therefore, in port cities, the customs and practices of marine commerce prevalent in ancient times have been compiled from time to time. If you look at Rhodian Sea law, which is perhaps the earliest such compilation at the island of Rhodes, Greek city state in the Mediterranean Sea, it is said that such culmination of rules is a result of 5,000 years of development and practice. So, we see that how long and how extended and how old is the practice pertaining to maritime law or admiralty law is concerned. It is just that 5,000 years before a particular name was not handed over to those rules and regulations, but ultimately we see that 700 years before, when the concept of admiral and admiralty comes into being, we see that all of these practices and customs fall within the domain of admiralty aspect, or you can say maritime law aspect. We see that island of Rhodes was preeminent to its strategic position at the crossroads of maritime traffic in the ancient world. Romans then incorporated the principles of this maritime law into Roman law, and for centuries the entire Mediterranean and Atlantic commerce of the Roman Empire was regulated by them. So, what do we see here? We see that the rules pertaining to maritime traffic in Mediterranean Sea were also in place. The practices pertaining to traffic of admiralty was also in place even in the times of Roman Empire. We see that other initial compilations are laws of Oleron in the Bay of Biscay near Bordeaux of France, Visby on the island of Gotland, and Hanstowns on Baltic. We see that in medieval times, western Mediterranean cities such as Venice, Genoa, Adriatic, Malfi, Ragusa, Pisa and Barcelona rose to eminence, and they also grew to be the place of high commercial transaction. That it was in 13th century that maritime laws and customs of the Mediterranean Sea were collated in a single compilation known as Consolato del Mare, that is the code of Barcelona, which is one of its kind. One of the most revered compilations in England is Black Book of Admiralty, as we have already discussed this particular part. Now, taking into account all of these backgrounds, we see that towards the end of 16th century, when we say that political power grew, it took control over such application of laws, especially the Admiralty part, where the jurisdiction of admirals and Admiralty grew. We say that the authorities, that is the admirals, their power of administration of justice expanded with the passage of time, and it also came up as a necessary requirement. As they started sailing from one part of the world to other part of the world, it was necessary that administration of justice powers be expanded and handed over to the admirals itself. But later on we see establishment of Admiralty courts itself, which comes in competition to common law courts. We see also that another source of Admiralty law has been the digest. Although digest is not considered as a source of law in English courts, however, it is accepted as source of law for Admiralty matters. This also identifies dissimilarity between the approach of civil law and common law. It was also observed in M.V. Elizabeth case that Admiralty action in rem as practiced in England and United States is unknown to the civil law. In countries following civil law, all proceedings are initiated by actions in personam. The president of the court, having competence in the matter, has power to order attachment of the ship if he is convinced that the plaintiff is likely to lose his security unless the ship is detained within the jurisdiction. His hands are not fettered by technicalities of an action in rem, and the scope of proceedings is not limited to maritime liens or claims. According to French law, arrest of ships is allowed even in respect of non-maritime claims, and whether or not the claimant is secured or unsecured creditor, the vessel may be arrested either for the purpose of immobilizing the vessel as security or in execution of judgment, whether or not the claim has any relation to the vessel. Maritime law is part of the general law of France and other civil law countries and is dealt with by ordinary courts and tribunals. This dissimilarity in contemporary times has also raised difference of opinion in various international conferences for unification of the law of the sea. So, therefore, when you look at other additional developments of the modern day source of Admiralty law, we can see that there is convention of unification of certain rules of law respecting collisions, Brussels, International Convention on Unification of certain rules of law respecting assistance and salvage at sea, Brussels, then Convention on limitation of liability, on unification of rules relating to immunity of state owned vessels, then Convention for unification of laws pertaining to maritime liens and mortgages, and then also pertaining to arrest of seagoing ships. Now, friends, when you look at Admiralty law and constitution as far as India is concerned, so generally Admiralty law is considered domestic law. However, it cannot be segregated from international scenario. Under the law of the sea, the application of domestic law is limited to territorial waters, wherein for certain matters such as revenue, public health, police and fisheries, it may be extended to contiguous zone as well. So, when you look at Article 245, clause 1 says, subject to the provisions of this constitution, Parliament make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or any part of the state, and no law made by Parliament shall be deemed to be invalid on the ground that it would have an extraterritorial operation, and we have seen that as well. Now, through this we try to understand not only the historical development, but also the peculiar feature and nature of Admiralty law. In the next class, we will in detail talk about action in rem and action in personam and what are the different claims and jurisdictions. So, in the upcoming classes, we will talk about all those things that have been introduced in today's module. So, with this, I would conclude this particular class. Thank you for your patient listening. Namaskar.